Mr. Mandel.
Thank you, Manu. We submit that the 2020 Upper Tribunal erred in law in its approach to the direct link test. As can be seen from that decision and from one of the judges in that decision's refusal of permission to appeal to this tribunal in the present proceedings, the tribunal adopted a broad, generic and flexible test. As you see in our skeleton argument, the acceptance test is broad in the sense, certainly, that it's not narrow, that it's generic in the sense that there is only one test that is to be applied, but whether it's satisfied will clearly depend on the particular circumstances. And whether the test is flexible or not. It's not flexible in the sense that the relevant degree of reciprocity can be dispensed with. And we submit that the Upper Tribunal lost sight of the need for the necessary reciprocity between the consideration, that's the payment received by the supplier, and the specific individualized benefit conveyed by the service provided. If we go to the tribunal's decision in the authorities bundle at page 201. You'll see that the tribunal's reasoning, after it had decided that Rayon d'Or was binding on it and disposed of the case, is found at paragraphs 75 through to 81, and then at 82 it stands back and tests its conclusions. You'll see at paragraph 81, which is on page 202, that the tribunal said this, that it accepted that the link could be more direct than it was. The funding was not specific to any particular course or courses, did not reflect the specific costs of any particular courses, nor did it identify the particular students who would take those courses. The law does not require such a degree of specificity. The concept of direct link encompasses a range of possibilities. And we submit that one should first remind oneself that we are dealing, when we look at reciprocity, with the basic VAT concept, the basic VAT unit, if you like, of a supply. And so here we are dealing with very many supplies made by CIC to many individual students. And we submit, taking into account our submissions in relation to supplies where the supplier is permanently available to supply services, and the particular distinction that we submit, the CJU has drawn in Rayon and in other cases in relation to that. In this case, there can be no direct link between the lump sum that was paid to the CIC by the funding agencies and the particular services which it provided to the students. I'm going to come back to that and degree of specificity, but the tribunal, we say, also lost sight of the need for a price to be stipulated in relation to each supply to each student. Just to remind ourselves, no prices for supply. Well, we submit that no price for the supplies of education to any individual student was stipulated here.
There were receipts though, weren't there?
Yes. So can I come on and deal with that?
That's fine, whenever it's convenient for you.
The court may be concerned with two questions. One was a price agreed by the student and the college, or secondly was a price agreed by the college and the funding agencies. Just to confirm to your ladyship and your lordships, the CJU basis for saying the price must be stipulated. Could I just take you to a case I'm going to refer to as Chesky Rojas, which is in the Foresters Bundle, tab 21. And it's paragraph 20 of the judgment on page 366.
On page
366. And I haven't taken you to the Tosma case, although it's in my skeleton argument, which in some ways is the foundation case. But that requirement for price to be stipulated is also found at paragraph 12 in that judgment. It's page 214 in the Foresters Bundle, and it's at paragraph 33 in the Balgaraska judgment, which I hope I took.
I'm sorry, I want to follow these references up. So can you just give them
yes.
me again?
So Tosma.
Yep.
A, tab 13, page 240, paragraph 12.
Thank you.
Balgaraska, authorities, tab 25, page 426, paragraph 33.
Thank you.
So on the facts here, we submit that there's no price being agreed and stipulated between any student and CIC.
Where was the price stipulated for a particular resident of a RCHE in Roundor?
Well, the formula there was a per resident formula. So the formula gave a per resident price.
Making certain assumptions as to how many residents there would be in the relevant year to which the lump sum payment related. But that degree of approximation didn't prevent the requisites of a VAT supply existing.
I think in our, sorry, if you finish.
No, sir.
In our submission, the formula was based on the actual number of residents in the care home, but it's obviously a possibility that the number of residents would change. But the position was the residential care home had to be permanently available to provide healthcare to that number of residents.
It wasn't a price per treatment.
It wasn't a price per treatment, but it was a lump sum formula which was clearly based on a per resident price. And the other important feature in saying that you could find the per resident price in the rayon context is the service being supplied to each resident was the same because of the way in which the CJU characterised it. That's relevant both in terms of if you looked at the supply to an individual resident, the lump sum becomes directly linked to the specific service of the provider being available as characterised. And also that's the same service that's provided to each resident. It may be that it will cost more to provide that service to one resident than another, but the same service is provided to each resident. that's very far away from the position here. Because I don't think we can say in rayon that there are always going to be the same number of residents as the actual residents when the number of care home residents is taken, but there is obviously a limit on it in economic reality terms of the floor on it, I think.
I think it shows there's some flex, at least, in that the actual supplies may be to a different number of, even the permanent availability supply may be to a different number of people within a
That's right, because
home.
it's not a supply to the national insurance sickness fund of being available for up to 20 residents. It's a supply to each of the residents. And of course, the Court of Justice doesn't go into any detail on that beyond its paragraph 36 and identifying the type of character of supply which we submit is relevant, but it doesn't say anything about apportionment.
And in fact, the way, sorry, I'm sorry to cut across you. And in fact, in rayon, the way that, as I understood it, the dependency element was dealt with in relation to the lump sum was not specific in any way. It was a general assumption across the board, which added an amount into the lump sum. It was not specific to specific residents or specific homes.
That's the way we read it. It doesn't seem to have been a result of visiting a home and assessing the dependency level. It was based on national
averages of dependency or whatever.
Yes. So we're being on the specific point allied to direct and immediate link, which was a price stipulated. So the economic reality between the student and the FEC here, CIC, is the understanding or the agreement is that the education will be provided by CIC to the student for free. There's no responsibility on the student to pay anything at all ever. If funding shouldn't happen, there should be a shortfall, then the student isn't required to pay anything. Now, your ladyship mentioned the receipts, and the receipts are just a figure that are placed on a particular provision of a particular course to the student. They don't in any way tally up with the funding that my learned friend relies on as being consideration for the supplies. So they're just figures that are put on. The college describes the figures as immediately being waived. The First Year Tribunal 2018 considered waiver wasn't an appropriate reference because there's anything description, because there's nothing ever to waive. There's never any obligation to pay anything. So, of course, that isn't the end of it. In third-party consideration cases, it's not necessary that a price for a service has to be agreed and stipulated between the recipient of the supply and the supplier. It can be agreed between the provider of third-party consideration and the supplier. And that's clear from cases such as the Supreme Court in Air Tools, which my learned friend has cited. But we say that there has to be, if the agreement is between the supplier and the third party providing consideration, a price stipulated for each particular service that is supplied. Where there's more than one supply service, here there are many thousands of supplies of education to students, a price has to be stipulated for each supply.
I'm just wondering about that word stipulated. I mean, if there's a bulk amount paid by me to you to supply 100 people, isn't it enough it's derivable?
Well, if a price is stipulated for 100 supplies of 100 for £100 for 100 supplies, and each supply is identical, then it's easy to see.
But if they're not identical, and my figure involves a weighted average for trying to allow for the extent to which they'll differ, there may not be a price per each of those 100 supplies, but it wouldn't be beyond the wit of the accountancy profession to derive a supply figure from the lump sum payable for the 100 supplies.
Well,
are you really saying that law requires a separate figure to be allocated point of payment to each individual supply that will be made?
The price or the consideration has to be stipulated. And we say that that is what's required by that law, and that cannot be got around in this context, where there are supplies by the supplier to different, in this case, very many different recipients of the supply, and simply by saying, well, there's a lump sum amount and it can be apportioned. Because if that were the case, it would just be a lump sum amount. Where there's a lump sum amount, it can just simply be apportioned to very many different supplies of different characters, of durations. Then it's very difficult to see why the Court of Justice was concerned in paragraph 36 with characterising the supply in order to determine whether there was consideration as a supply of the making, the service provider being available to make supplies.
But will authority for the stipulation proposition be found in those cases you very kindly gave the references?
Yes, it doesn't follow through and give detail as to what is required for a price to be stipulated.
And is the word stipulated, is that one that appears in legislation or case law? Is that just your description of what is?
So stipulated. Sorry, I didn't flag it enough when I did talk about
in paragraph 20, the word stipulated.
Paragraph 20. In that regard, it must be recalled that within the framework of the VAT system, taxable transactions presuppose the existence of a transaction between the parties in which a price or consideration is stipulated. And that's repeated in the other two cases to which I referred to at that point.
Thank you.
In this case, I go back to on the facts points that I've made before, in that the number of students who will be provided with education during the relevant academic year is not agreed or determined. Certainly not in the agreement between the EFA and the CIC. The courses that will be taken, their type, their length, their subject matter, are not determined. It's all left to the choice of CIC within the parameters of providing education which leads to an approved qualification, but that's a very wide parameter. And we say that those are very important considerations which show that there can be no direct link between the lump sum and the series of supplies of education to individual student. And we say that's not a cause for concern and doesn't need anything drawn into the VAT system to sort of cure that in a situation which we're looking at, where there is a perfectly ordinary other explanation of the role of the funding, which is that it's provided to an institution such as an FEC so that it can carry out its functions and it can provide with the funding that it has education to students who are within their categories that the funding agreements permit them to provide services to. So it's not necessary to come up with a satisfactory or realistic analysis to treat what's happening here as a lump sum purchase by the EFA, say, of the provision of education to students, and the fact that there is no price agreed in respect of individual courses by the EFA and individual courses for each student or per student is a good indication that that is actually the correct characterisation of the funding here. I mean, it would be perfectly easy to say by the funding agency, we're going to pay you X pounds for this course and Y pounds for this course for each student you provide it to, and even that we're going to give you advance payments on certain assumptions, but we're going to have a reckoning up at a later period and adjustment. But that's not what happens, certainly not what happens in relation to the EFA.
Are you suggesting there may be a different answer as between the EFA and the SFA?
No, it's possible that there could be one, but no, we say the answer.
No one seems very attracted.
The same. No, and it might not overcome the disadvantages which many further education colleges will face if these activities are held to be exempt supplies for consideration, because although they're exempt, that means that they're in business and it affects their ability to claim zero rating in respect of buildings and reduced rating in respect of fuel and the like. So I think that split, although theoretically possible. But the difference between the SFA, I submit the main difference between the SFA and the EFA, is that the SFA has a clawback mechanism which operates if there is, may I call it, under-delivery in a particular academic year, to claw back some, at least, of the funding which has been provided for that year.
This is what was puzzling me, and this may be a good time for you to help me. Supplementary bundle, tab 5, I understand, is the EFA funding agreement. A template.
Yes.
Pro forma.
Can I don't think that's going to help us, my lord. Could I suggest we go, and it's partly in trying to answer your lordship.
Can I, before we depart?
Yes, sorry, I beg your, that was possibly rude of me. I didn't intend
not at all, but it's clause 4.8 that troubled me.
Sorry, which page is this, my lord?
So I started on page 15, which I had assumed was the EFA funding agreement.
Yes.
And then if one goes to page 23, clause 4.8, there looks to be an ability to audit by reference to actual student numbers and claim repayment within 30 days of providing an invoice. Now this, I may have totally misunderstood this.
Sorry, I haven't listened carefully enough, so I don't know which clause your lordship.
4.8.
Thank you. My understanding, it's rather tentative, as I read this anyway, was that it relates to overpayments over the overall maximum value. So where the overall maximum value has been exceeded, which my understanding is it shouldn't have been, then there can be a recovery of amount paid in error. And the fact that it refers to an error doesn't suggest that it's amount properly paid in accordance with the EFA's funding formula. It wouldn't be an error to pay an amount that was due to be paid on the basis of the funding formula. I believe this is a generic document that my clients obtained and put before the first tier tribunal. You'll see that Appendix 1 and Appendix 2 are blank.
Yes.
Are blank. I think his Lordship, Lord Justice Arnold, said it could be helpful to see provisions relating to clawback, if we're calling it that, under the SFA agreement. I'm not sure that we have the totality of the conditions, but if you were going to the supplementary bundle at page 101,
And this is the SFA. Yep.
yes, it's an SFA document now, Operational Performance Management Rules, 15 to 16. And if you then go on to page 106, under the heading 16 to 18 apprenticeships and SFA funded traineeships, so it's page 105. It talks about performance management points. And you can see that it says that performance is reviewed if delivery is more than 6% below the standard national profile. The contract value will be reduced by some or all of the value of the under-delivery to date. And then they won't agree an increase to that contract value. So our understanding in relation to SFA, as recorded in the facts, is that there can be an in-year adjustment by the SFA in relation to under-delivery, but there is no adjustment in relation to over-delivery. Then, whilst we're in the bundle, if you don't mind me taking you back to a document I took you to this morning on page 176, this is now EFA. This is a 16 to 19 allocation statement for the 2016 academic year. And you'll see from that page for that year, the funding allocation is over 18 million for programme funding used applying the formula. And then there are smaller amounts of just under and just over £500,000 in respect of high needs student funding and student financial support funding. And you'll see the references to the tables. I don't think it's proportionate to take you there, but the relevant tables are on the immediately following pages. And here we see vividly for 2016-17 how the formula works. You have student numbers for 2016-17. Perhaps it is worth looking at seeing how in practice those are arrived at. You'll notice the figure is 4,105. If you turn over the page onto 177, you'll see there's a total number of students taken at a particular date, RO4 2015-16. And then there's a ratio, so it's 1.017, which is taken from period RO4, return RO4, I think, in 2014-15. That's used to multiply the figure at 1.1a, and that gets 1.3a total lagged student numbers. And you can see that there can be exceptional variations, but the word's here.
And then, I'm just looking at the boxes on 176.
Yes.
Because you've got 4,105 students. The next box you've got funding rate per student, £4,000. And then you've got the total of 15,381 odd. And that's made up on the next page, on 177. You've got that table with the breakdown of the planned hours and the bands and the percentages within the bands to get to the 15,000 odd, I think.
Indeed.
So in respect of those 4,105, you've taken proportions from another period in order to determine what the percentages are within the bands in order to get to your 15,000.
Yes.
Okay.
And then you have the retention factor, which is 0.952. So that reduces the figure being carried forward. Then you have a programme cost weighting factor of 1.115, which increases the figure going forward. And then you have disadvantage funding, which takes into account various disadvantages, and I think often based on the postcode areas that are relevant. And then there can be, that's additional though, not a multiplier, the disadvantage funding, added is kind of large programme funding, not to Colchester, I think, in any of the relevant years. And then the area allowance cost, which is 1, so not increased or decreased. But the position in relation to EFA funding, as in the findings of fact, is that in year, if I call it that, there is no adjustment of funding in respect of under-delivery or over-delivery. So we've seen that. just want to go back on the price point. We can see, particularly vividly, I think, perhaps from the EFA page we've looked at, that will generate a lump sum used in generating that lump sum is a number of students. It's not the number of students to whom education is actually or has to be provided by CIC. As you see, it's based on students in earlier years. And we certainly submit that the fact that there is an element in the funding formula which is based on historic numbers of students doesn't give any support to the conclusion that there must be a direct link between the lump sum and the education provided to students. It's commonplace in public bodies funding agreements that there will be a figure included for the number of expected consumers. But that doesn't, of itself, that can't be sufficient to create a direct link. And in this funding formula, there are amounts and potential amounts like large program funding and disadvantaged funding, which are not by any means a per student factor. They're added in on top. Although there is both a national funding rate per student and program cost funding, in our submission, and contrary to what the Upper Tribunal found in its 2020 decision, there's not enough to establish or give significant support to the existence of a direct link. What the tribunal said at paragraph 78 was the formula was highly specific to CIC's outputs, the number of students, the type of students, the number of courses, and the type of courses. And in our submission, that's an incorrect appreciation of the funding formula when properly considering it in terms of direct and immediate link, because what it's doing is not properly recognizing the need for reciprocity in the sense of a link between the specific benefit provided and the payment received. And although we venture that that could be done as a type of supply in the rayon case, albeit accepting that there must be some degree of flexibility, that can't be done, we submit in the circumstances of CIC's education, funding by the funding agencies and provision to the students. And we say one way in which it can be tested is it's not economically a realistic view that consideration for each supply to a student will change, because rather than CIC providing in an academic year education to X students, it provides education to 500 or even say 100 fewer or than X, or to 500 or say even 100 more than X. That's not saying that there has to be the quantum of the consideration, the amount of the consideration has to align with the costs of the supply that's made by CIC, but it's indicative that there is no sufficient reciprocity between the lump sum payment and supplies made to individual students. And one can see that, and in our submission, what one sees when looking at this funding formula is characteristic of the funding of a body by a funding agency, rather than the purchasing of very many supplies of services to be provided to others, such as students. Just wondered if we could go back into the supplementary bundle. Perhaps I should have done this, my lord, when you looked at it originally. But I think if one just looks at the agreement, I don't need to take you to all of it. But if we were to go to page 52, just look at responsibilities of the governing body.
So this is in the SFA agreement.
This is, yes, in the SFA agreement. So if you just look at 3.1, not so much solvency, but responsible for achieving value for money for all in all transactions involving public funds. And I don't think 3.3 or 3.4 help. But I did also want to see in 5 provision of information, 5.1. And that's something which we have placed weight on and found itself into the statement of agreed facts and the findings of fact by the Tribunal, First Tier Tribunal 2024, paragraph 6.2. I realise that's both a freedom and subject to the conditions of funding. And there's a repayment requirement at the end of 5.2. If it's used, public funds in a way not specified. And then on conditions of funding, 7.1 and 7.2. And I think that ties in probably with the clause that you took me to earlier, my lord. And appendix 1 is blank, unsatisfactory.
I think the clause that we were looking at was in the EFA rather than the...
Oh, sorry, I beg your lordship's pardon. Indeed it was.
But before we move away from this document, the SFA document on page 54, we've also got paragraph 8.1 about the college must supply data on each individual earner.
That's right, and which is a broad point anyway, which the Upper Tribunal relied on. But in my submission, that is a modern 21st century way of a funder reviewing whether they're getting value for money from their funding. And it's equally compatible with that as with any suggestion that information must indicate that there is a supply for consideration. And in our submission, the Upper Tribunal erred in its, if you want to go there, it's on page 202, paragraph 80, please. And you'll see there, my lady, that there's reference to the ILR, the individual learner record.
Mm-hmm.
And we know for the SFA, it was possible for the SFA under the terms of funding to reduce funding for under delivery, presumably on the basis of that. I think the information requirements for the EFA are very similar, and there's no comparable ability to reduce in-year funding there. My learned friend relies quite heavily on apportionment as a way to establish the direct link when one has a lump sum. My intention is to respond to his submissions on that when he makes it. I've already made the broad submission that apportionment can't compensate and overcome the necessity to have a reciprocity between a service with a specific benefit and a payment. You just want to say this. He referred in his skeleton to a CJU case of Field Fisher Waterhouse, which is a case very different from this in that it's simply a question of two different services being provided by one service provider to one client. Actually, it was to tenants in a block of flats. It's probably that replicated many times over, but it's just a relationship between one supplier and one customer, and the customer is providing the payment, and in that case, attribution is permitted to break the agreed price down between the two suppliers if you need to, because that's one's taxable exempt. And the other case he refers to, I remember, is the KE Entertainment's case, and that's the same in the sense that one's simply looking at one payment made by one customer, a gambler, to a company supplying gambling services, bingo services. And in that case, there's a single amount paid, agreed between that customer and the supplier, but it needs to be apportioned because it's accepted in the proper VAT treatment. Part of that payment is consideration for supply of gambling services, and part of it is a stake, which will go towards funding prizes. But again, it's just one supplier and one recipient of the.
Why does the third party point change the analysis there, assuming that I paid this amount of money instead of the gambler, but for exactly the same thing? Wouldn't the same point arise?
Well, in our submission, no. And again, I buttress that answer by saying, well, paragraph 36 of Rayon doesn't sit very easily with that in terms of lump sum. But particularly say that if that is a possibility, then it can't just be said that you can have an apportionment. Some apportionment can be made out, and that would satisfactorily establish a price or establish consideration referable to particular supplies. And the reason for that is that you simply don't have, we would say, the prior stage which is necessary, which is to establish that the consideration is actually in return for particular supplies. There's no difficulty with that in the Field Fisher Waterhouse case, but in our submission, it can't be got around in circumstances where, as I've described, the provider has a choice as to the number.
Well, I think that drags us into the remainder of the argument, but the proposition I'm querying is whether different rules of attribution apply when you can do it, as between 2 and 3 party scenarios. You seem to be saying they do.
Well, in my submission, with the possible exception of rayon, but my submission on that is that you can see a per person price there. There isn't a case which shows that can be done.
Or that it can't.
No, there isn't a case that shows that it can't be done either, but my learned friend can't produce any case to you which shows it can be done. So I think it's right that I try and make sure that we've covered all of those paragraphs from paragraph 74 on in the 2020 Upper Tribunal's reasoning. And there's a point that I need to come back to answer her ladyship's point in relation to retentions in the following year by the EFA. Could I just invite you to read paragraph 79 on page 201 of the core bundle, the authorities bundle, CIC UT 2020.
Yes, there were 2 different mechanisms, but for the similar purpose.
Well, we submit with respect that the Upper Tribunal erred there.
Okay.
So just note that there's no adjustment ever made for over-delivery by either. In year, that is. And there's no adjustment for under delivery by the EFA in year. and the Upper Tribunal acknowledges that. But it says the fact that the EFA retention applied in the following year and did not affect current year payments is not significant. And we say that's not right. The case that we've all been looking at in my submission is that the grant funding given for the academic year 2015-16 is consideration for the supplies made by CIC to many individual students in that same year. There's at least a chance that crystallised in the UT's decision of funding for 1 year being consideration for provision of education in the same year. But what the Upper Tribunal mistakes is, and then ascribes VAT consequences to it, which can't be sustained, is what is a normal or typical response to a funder, by a funder, to underperformance of a body that it's funding. So it's not satisfied with its performance in year one. And so when it comes to allotting funding for year two, it reduces that funding for year two by reference to the underperformance of the organisation in year one. But that's not an adjustment to the funding in year one. That's a decision as to what the appropriate level of funding is for year two. And in practice, if, as I understand it, if significantly fewer students are educated by an FEC in year one, they will get significantly lower funding in year two, unless one of the other elements in the funding formula is increased by the EFA. And so that alteration to funding in year two can have no impact at all on the consideration for the provision of education made in year one. And in our submission, that must be the correct VAT analysis. So,
do you submit it's irrelevant that it's an incentive to the provider not to under-deliver in year one?
In our submission, that's a typical way in which the progress of public funding year to year.
It's a sanction for non-compliance, and the point of sanctions is to incentivise people to comply.
We would say each year has to be viewed individually in VAT terms. Your performance as an organisation being funded in year one may not be thought to be satisfactory in year one, and that may result in you being allocated less funding in year two. It's a perfectly rational approach for a funding body to take, but that's characteristic of an approach to public funding which has nothing to do with the purchasing of supplies of goods and services. If you're purchasing supplies of services and you require a reduction in consideration for underperformance, that needs to be provided for in the terms of the agreement applying to the relevant services, which for 2015-16 services is the 2015-16 funding agreement.
I think we understand that now. Mr. Mantle, I'm becoming very concerned about timing. Are we nearly to the end of the things that you need to say?
Yes, we are, my lady. My calculation was that out of, I think, the 7.5 hours we still have, that it would be reasonable for me to take...
7.5 hours, that means that you think you've got all day tomorrow?
No.
Are you sure?
No. We have, I believe, until either lunchtime tomorrow, or we thought the court might generously be saying if we needed it we could have the time which we lost this evening.
You most definitely can have the time, the half an hour that you're going to lose this evening. But this appeal must be over by lunchtime tomorrow.
Very good.
And so I just was concerned that Mr. Firth's time is beginning to ebb away.
I note that concern. I'll be very quick. I may actually may be able to finish almost as much time as I've taken to explain myself.
I think you probably have almost.
Yes. Yes. I think, in fact, the final point that I was going to make was on paragraph 82.
Thank you.
Of the tribunal's decision. This is a relatively soft point because the tribunal, having reached its conclusions, stood back and said that it was satisfactory that one didn't have what might feel like a discrepancy in the VAT treatment of students who were paying their own fees and students who benefited from grant funding from the agencies. And I think at the end, the tribunal didn't think that could carry them anywhere in particular, because if they needed to be uncomfortable with that because it was the right result, they would be uncomfortable with that. In my submission, my lady, there's no need to be uncomfortable about persons in the same room receiving a supply for free and the same supply for consideration. That could happen in many contexts where a business, certainly if it had a legitimate objective to do so, like the further education colleges, was prepared to provide education to some students for free and had the financial backing to do that, but wanted to charge students in other categories of fee. So that there's nothing carrying any weight against my submissions there. May I just check that I haven't omitted anything? I'm very grateful, my lady.
Thank you. Thank you very much indeed. Mr. Firth.
Thank you very much, my lady. In light of the time, and bearing in mind that we must finish at 3:45 today, what I propose to do is to give the court some, I won't call them headline points, but key points that address many of the more significant features of my learned friend submissions. Then I'll consider overnight what I need to delve into in perhaps more detail from my skeleton argument. If I may begin by explaining how we see this case in terms of supplies for consideration. We see it as the respondent offers courses. The students choose those courses. We don't choose the courses for the student chooses the courses. So the idea of us having autonomy over the student course is only correct insofar as we decide what we offer, but that's true of pretty much any supplier. The student chooses the course. Some of those students are eligible for funding, and they are entitled to waiver of a fee or free education, whichever way you want to put it. And we say, and this is what I'm going to develop in a moment, that Colchester is paid for providing that education to those students on those courses by the funding body. It's that simple. We can get into significant complexity of looking at formulas, and we will do that. But at a very simple level, what is that money being paid for? It's being paid for the consumption by these students who've chosen these courses. My learned friend seeks to paint this as some sort of generalised funding of Colchester's educational activities. But with respect, that can't be right. It cannot be right to characterise the funding as being general to Colchester, because the funding bodies, the Secretary of State, are not funding the non-eligible students. even though they're all taught together. Indeed, to be funding those other students would seem to be ultra vires. That's not what the power is there for. So this is not a general subsidy. Not a general subsidy for Colchester's educational activities. It's very specifically funding for these particular students who've enrolled on these courses to pursue those courses. And you saw that. The court saw that when you were taken to the funding formula. Page 176 of the supplementary bundle. I'm not sure you need to see it again so soon. But it is highly specific to Colchester's outputs, almost to the hour, in terms of trying to estimate exactly how much time are you going to spend educating these students. And yes, it uses lagged student numbers. But it's using that as a proxy. It's trying to estimate exactly how much education is going to be supplied to these students in this year. And there are obviously sensible commercial reasons for doing that. I'll talk more about that when we look at the agreements probably tomorrow. But when the Upper Tribunal says it's a highly specific, the outputs at paragraph 78, well, we agree. And it does beg the question, my learned friend submissions, is would we be here? If the funding formula had instead said, instead of lagged student numbers, current year student numbers, would we be here? Would HMRC then have accepted, well, in that case, clearly you are, through a formula relating the payments to the actual number of supplies in that year? Our belief is we wouldn't, because then you can clearly see even on HMRC's analysis. And so that then begs the question as to, well, is it right that you fall outside the scope of VAT in a third-party consideration case, or presumably any case, by using a formula that calculates the payment for the supplies to be made based on estimated use rather than actual use? And, well, I struggle to believe that can be correct. Just before I leave the formula, my learned friend did make a submission that, well, look, there are certain elements in the formula that might not relate to students at all. It does not need to be the case that every element going to calculate the lump sum relates to students. All that matters is that the supply is for some consideration. And so if you sort of had a formula that was very specific to students, using actual numbers, actual hours, and then some sort of additional payment on top that didn't really relate to students in any way, there's absolutely no reason why you wouldn't say, well, part one of the formula is the consideration and part two is something else. That's entirely possible. So I don't need to prove that every element of the formula is consideration. And if I may briefly deal with Rayon now, and I'll think overnight what I need to say in more detail, if anything. But this, in that respect, is exactly the same. Because in Rayon, you had, put to one side for a moment, this debate as to whether it's a Kenema supply, an extension of a Kenema supply, or something else. On any view, it was multiple supplies to each resident. I think, well, I know because I heard it. Both sides agree that. So on any view, Rayon was a case of multiple supplies to each resident who happened to be their home at a particular point during the year. And whether that's a home with 30 residents or more or less, the principle is exactly the same as our case where we've got multiple students. Because my learned friend tried to make a big deal of the fact, well, look, Mr. First saying this lump sum is consideration for, let's say, 2,000 supplies of education, as if that was a point against me. But exactly the same point could be made in relation to round all. That lump sum was consideration for a supply, individual supplies to 20 residents of the home, let's say. So it's exactly the same point. And in terms of, therefore, the use of a formula based on number of residents and dependency and other factors, it is exactly the same. And assuming that formula in Rayon wasn't based, and it's difficult to see how it could have been based on the exact number of residents on day one of the funding period, then it's necessarily going to be based on an estimate, even if it's an estimate taken a week before. Somebody could die in that week, you've got 19 residents rather than 20. It doesn't look like there was any adjustment for that. And in any event, I think we both agree that in Rayon, the identities and number of residents could and probably did vary through the year. And that's significant. That's very significant because it means that given we accept, both of us accept, this is not a supply to the insurance company, this is individual supplies of some kind to each individual resident for a lump sum, let's say it's paid at the beginning of the year. If somebody drops out and somebody joins during the year, now you've got a supply being made to that person based on a lump sum that was paid months before they ever even thought about living in the home potentially. But that doesn't concern the Court of Justice. Really, as my Lord said, they're simply confirming, yes, this lump sum is consideration for those supplies. And they say the same thing in Kennemer, and they say the same thing in Soudacor, that lump sums for multiple suppliers to multiple persons can be consideration. That's what it's saying. If I may just pick up on the dependency point, I don't say it matters. I think the key point from Rayon is that it was multiple suppliers to multiple individuals, same as our case. But in terms of the link to dependency, if we just please look briefly at page 290 in the authorities bundle to see, so it's page 289 going into 290. This is the explanation of the funding formula. The court says, according to the statement of the referring court, the detailed rules for calculating the healthcare lump sum take account of the number of residents posted by each home and their dependency level. So it's the residents of the home's dependency level that's assessed, which are assessed in accordance with the conditions set out in certain articles and of historical coefficients which are determined. So I'm not sure the historical coefficients are applying to the dependency, but on any view, it seems like the dependency does in some way take account of the individual. And in fact, it must do, because there'll be no need for a separate consideration of dependency if everyone was assumed to have the same level of dependency. You would just have a figure per person. So I don't accept there was a single sum per resident. It seems like it wasn't. For example, it could have taken an age bracket and said, well, persons in this age bracket give rise to X. And that would make sense, because if you have someone who's highly, highly dependent, you wouldn't expect the same price as someone who's not very dependent. So it wouldn't make sense not to take into account at least some features of the individual. But I think this is sort of a side point. All I'm doing is showing you that even there, they are particularizing it in some way to what must be the expected residence at the beginning of the year. And so the Rayon does provide the answer in that sense, because it rules out HMRC's argument as to why this case must be treated as not involving a supply for consideration, because there is no relevant distinction. There are multiple suppliers to multiple individuals, presumably based on an estimate of who's going to be there at the start of the year, and furthermore in Rayon, we both agree that the identities probably vary through the year. That didn't stop the Court of Justice saying, yes, that is consideration for the supplies to those residents. I find it difficult to see what my learned friend says about Mr. or Mrs. X who turns up in month 3 of the year, having not been thought about at the time of the initial funding formula. Is that person being supplied for free, or are they being supplied pursuant to the consideration already provided? Logically, it must be the consideration already provided. So that's what I want to say today about Rayon. I'll think about how much more I might need to say overnight. I then turn, if I may, to the test. It's a direct link test, But we only get so far by thinking for ourselves in our own heads what a direct link might or might not look like. We have to go to the case law to see what's been said about that. And if I may show you first the Court of Appeal decision in Wakefield. And what I'm going to show you there is that the court talks about the direct link test in terms of poor consideration and explains it is a broad, generic, and frankly quite flexible test. And then it talks about the test in terms of economic activity. This case doesn't concern the latter, but it's nevertheless helpful to look at that. Could we please go in the authorities bundle to tab 8? That's where the case begins. And this was an education college, Wakefield College, who were asking or had asked for 0 rating of certain building work, which depend on whether they were going to use the building for in the course of furtherance of the business. You see that at paragraph 3 and note 6 just by G. So this is the 0 rating legislation on page 1008. Paragraph 3, note 6. Use for a relevant charitable purpose means use by a charity otherwise than in the course of furtherance of a business. So it's important for that purpose for Wakefield to establish it wasn't using the building in the course of furtherance of a business. HMRC was saying you were. The basic fact was that they were charging certain students about 25 to 30% of the cost of their course. And that was the basis on which Wakefield was saying, well, we're not using for a business. HMRC said you were, and the Court of Appeal agreed with HMRC. But that's the context. And there were 2 issues the Court of Appeal looks at. The first one is whether in supplying the education for a contribution of 25 to 30%, was that a supply for consideration? And second of all, if there was a supply for consideration, whether the whole thing amounted to economic activity. Before it gets there, it starts looking at the case law, and it deals with a case called Borsell, Commenti Borsell, at paragraph 16 on page 110. And if I just ask you to read paragraph 16 so you can see what the facts of Commenti Borsell were, please. Transport being provided for a contribution that depended on the factors you can see there. And what the Court of Justice did, and we can see the Court of Appeal explaining this, is it said, well, that is a supply for consideration, but it's not an economic activity. And that's at paragraph 28, please, on page 112, at the bottom there.
Yes.
In terms of economic activity, the Court of Appeal quotes at paragraph 30 of the Court of Appeal judgment on page 113 certain passages. And if we could just look within the quote, please, at paragraph 34, it says, it therefore follows from that lack of symmetry that there is no genuine link between the amount paid and the services supplied. Hence, it does not appear that the link between the transport service provided by the municipality in question, the payment to be made by the parent, is sufficiently direct for that payment to be regarded as consideration, French version, remuneration, for that service, and accordingly for that service to be regarded as an economic activity within the meaning of Article 9. Now, what we'll see in a moment is that that paragraph is not saying it's not consideration in the Article 2 sense we're talking about, it's saying it's not remuneration in the Article 9 economic activity sense. But you can see there, it's using this concept of a sufficiently direct link which explains and confirms that there are a range and there is a spectrum of how close and direct a link may be. And a link may be sufficiently direct to be consideration, but insufficiently direct to be remuneration. So it is a test that's broad, flexible, and generic. If we go then please to paragraph 45. This is now talking about the Longridge decision in Court of Appeal, and it's explained. Paragraph 45. It explains Lady Justice Arden examined decisions of the Court of Justice culminating with Finland, despite the element of confusion between the concepts of consideration and remuneration found in HMRC submissions. Lady Justice Arden, in the course of discussing Finland, identified, it seems to me, to be the essential difference between them when she said, all the factors which generally make a payment to the supplier of a service consideration for it were present. There was a link in terms of reciprocity, but the charge bore little relation to the actual cost, so the link was not sufficiently direct for there to be an economic activity. So again, you see there the concept of sufficiently direct to be consideration, but not sufficiently direct for economic activity. Actually, Lord Justice David Richards says that this is not a helpful way of looking at, of sort of explaining things generally, because it's liable to confuse, and we can see that at paragraphs 57 and 58. In terms then of examples and explaining and understanding where is the threshold for a direct link for the purposes of consideration, I've referred in my skeleton to the Airtours case for the proposition that in a third-party consideration case, you look at reciprocity from the perspective of the supplier. I might take you to that tomorrow if I need to. But just now, given the emphasis we heard this afternoon on stipulation of prices and similar, if I may just show you the cases I put in the supplementary authorities bundle, precisely actually to deal with this point in terms of direct link. So if we pick up, please, the supplemental authorities bundle. I'm not going to take them in the order they're in the bundle, but if I could take you first to Jamina L, that's at tab 3, begins on page 53. And we can see the facts at paragraphs 13 and 14, please. Essentially, therefore, we have a municipality being funded to do asbestos removal for inhabitants. At paragraph 15, we can see that the way it worked, looking at line 4, first, that municipality envisaged issuing a call for tenders in order to have that work carried out, with the successful tenderer having to issue invoices, including VAT. And second, on the basis of those invoices paid by it, the municipality then intended to obtain subsidies from that fund of an amount covering between 40 and 100% of the expenditure incurred on the basis of compliance with the conditions laid down by the fund. could look then please at paragraph 33 on page 59. This is in relation to an agency argument, but it's actually relevant to what my learned friend's been saying, because it says, thus by agreeing to participate in the municipal procedure for the removal of asbestos from their removable properties, the owners concerned merely submit an application to the municipality, which checks whether those properties are eligible for asbestos removal. Consequently, the owners do not entrust the municipality with the task of eliminating asbestos on their behalf, but hope to be recipients of the asbestos removal programme. It is therefore the municipality and not the owners concerned which decides on the success of that approach. Apart from the submission of an application, the owners concerned have no influence on the provision of those services, which again has resonance with what HMRC tried to characterise the present case as, in terms of there is discretion as to who we accept and who we don't accept. Well, that's what they're saying with the case there. We then get to the answer on whether it was a supply for consideration at paragraphs 35 to 39. Could I ask the court please to read those paragraphs? You can see in paragraph 38 that what the court places emphasis on in terms of saying, well, yes, there is a sufficiently direct link here to amount to consideration, are first, that the activity wouldn't have been envisaged without the assistance of the fund. Second, I note that it says, well, the absence of a contract between the fund and the relevant resident doesn't affect the existence, or doesn't mean there's no direct link. And then it says at the end of 38, well, since the supply of services and its consideration are mutually linked, as one is carried out on the condition that the other is also supplied, and vice versa, there's your direct link. And that's what I say, it's a reciprocity test. And there you can see, well, you only did this because you were going to get the funding. You wouldn't have envisaged this activity without the funding. And therefore, it doesn't matter if there's no contract between the funder and the resident. That's sufficient to mean that that payment is consideration for that supply of a service to that individual. I'll tell you, it goes on to say it's not an economic activity. The main reason seems to be because the municipality couldn't possibly have made a profit, given it was only reimbursed 40 to possibly 100%. It was always going to be loss-making. But we're not concerned with economic activity in this case. But I just tell you that so you know. The ultimate answer, that begins at 41. And in terms of a price being stipulated, well, of course, in that case, there doesn't seem to be any suggestion the resident knew what the price was or cared what the price was. Instead, it was based on some formula that resulted in 40 to 100% reimbursement. We then have cases like Zlakov, which is the next case I'm going to show you, where the price to the customer was said to be free, but because there was a payment under a particular piece of legislation, that was the consideration. So if we turn please to tab 4, it begins on page 63, and we can see at paragraph 10 and 11 key facts of the case. facts, therefore, were that the TPT were providing legal assistance, so-called free of charge, to the customer, but if they were successful, then they could obtain a payment from the losing party. If we go then, please, to paragraph 24 on page 68. Yeah, so probably, if I could ask the court to read 24 to 27, please. Accordingly, you had a situation where, as between client and lawyer, contract said, well, this is for free, but there was separately an arrangement, statutory arrangement, that provided, well, if you're a successful lawyer, you will get paid by the opposing party. And the court had put those two things together and said, well, there's your reciprocity. If you provide these services, contingent upon being successful, you will receive a payment. What is that payment for? Well, it's for the services, even though they were described as free to the actual recipient of the services. The risk, the contingency, we can see at paragraph 33 didn't affect that direct link. 33 says, although in the dispute in the main proceedings, the payment of the lawyer's fees is subject to a risk depending on the outcome of the trial, those fees represent, however, effective consideration for the services consisting of the representation of the client in the court. And that's the substance of the test. It's really just asking, is that payment for that service? And if it is, then it's consideration. You can see there, is it effective consideration? The fact that it comes not under your arrangement with your client, but under a separate statutory arrangement, doesn't prevent it being that effective consideration. A more complicated example, but actually I think very important in light of what my learned friend's been arguing, is the Marks and Spencer's dine in, get a free bottle of wine offer case. Because my learned friend has now placed significant store on the idea of a price being stipulated. Well, this case and my submission shows that can't be interpreted in the quite literal way my learned friend does. The facts, so it's in my supplementary bundle, and the facts are possibly familiar to the court in the sense that there was an offer that if you went to Marks and Spencer's, you could get 3 food dishes for £10, and if you bought the 3 food dishes for £10, you could have a free bottle of wine or other non-alcoholic beverage. The idea from a VAT perspective being that, well, food is 0 rated, wine is not 0 rated, the wine is free, therefore there's no VAT. Unfortunately not held to be the case. If we go please forward to paragraph 104 on page 49.
Because the wine wasn't free, it was included in the price. Usual story.
Yes, but I think the interesting point is that if you turned up at the till with 3 items of food, you would pay £10. If you turned up at the till with 3 items of food and a bottle of wine, you would pay £10. So where's the price stipulated for the wine?
There's no such thing as a free bottle of wine.
Well, that turns out to be true. If we look then, getting essentially to the point, you can see at 101, Upper Tribunal says, in our view, the payment of £10 constituted consideration both for the 3 food items and also the wine. There was a direct link between the provision of the wine and the payment of the £10. The wine would not be provided unless customer paid £10 at the till. Furthermore, there was reciprocal performance. But as I've noted, no price stipulated for the wine. In fact, the wine said to be free. And the Upper Tribunal deals with the point that, well, customer could equally pay £10 and just have the 3 pieces of food. And that's dealt with at 104 and 105. The analysis is not affected by the fact that a customer would have had to pay £10 for the food items even if the wine was not supplied, either through customer choice or lack of availability. We see no reason why the supply of the 4 items should be treated differently simply because in a small minority of cases only 3 items were supplied for £10. As we have said, in over 99% of the cases the customer was supplied with wine, which suggests for the vast majority it was significant. But then this at 105. In the end, however, we do not think that the proportion of customers opting to take the wine is of any legal significance. The customer has a choice whether to take just the 3 food items or the 3 food items and the wine.
It's a kenema supply of the wine.
That is a
Permanently
well, what is a
available.
kenema supply is a question all of its own. But yes, there's, well, potential availability of a bottle of wine, as we've noted. It may not be available through customer choice or lack of availability. For those who only take the food, they pay £10 and receive the food items. For those who take the wine, they pay £10 and receive the food items and the wine. The question is what the £10 is consideration for in the latter case, and it does not matter whether this happens in a minority cases or in a majority. And we say, well, that's the same point here. We've got a lump sums paid over the year. They are paid in return for the supplies of education to those particular students. And it doesn't matter that, but on different facts, the same sum might have been paid for a different number of students, because that's not the facts we're dealing with. As in M&S, the facts you deal with are the facts that customer turns up at the till with. If they turn up with three items of food and a bottle of wine, £10 is consideration for those. If they turn up with just 3 food items, it's consideration just for the food. And so if, as is obviously the case, X number of students are signed up in a year, and X number of students are each receiving a supply of education, the lump sum is the consideration for the supply of those items or those to those students together as a group. And as I've said in my skeleton, my learned friend addressed it briefly, you portion it, you need to. And there doesn't need to be a formula agreed in advance. And we see that in the Marks and Spencer's case, because there was no formula for dividing up the £10 between the wine and the food. You can see at 107, the Upper Tribunal says, accordingly, in our view, the FTT correctly decided that under promotion, the customer paid £10 in order to receive the 3 food items and the wine, with the result that the consideration must be allocated across the 4 items for VAT purposes. This conclusion is supported by the consequence that it avoids untaxed consumption of wine, on which M&S has claimed input tax. There doesn't need to be a price stipulated for each supply. In fact, we probably won't have time to do it today. The actual test in terms of the consideration and method of calculation is very, very loose. It simply needs to be ascertainable in advance and doesn't need to be allocated to each individual supply. Marks and Spencer is applying that second point. You will come up with a method if you need to. In most cases you don't need to if they're all the same rate of VAT, but if like in M&S they're different rates of VAT, you'll come up with a method. Just again in terms of this supposed stipulation of a price point, 106 refers briefly to the NCP case. Now the basic issue there was that in the days before mobile phones and cards in parking car parks, you would put coins in. And if you didn't have the right change, you might have to pay more than the minimum required to obtain that level of, or that duration of parking. And the question was whether that excess over the minimum you would have to pay was consideration for a supply. If you read 106, you'll see that the Court of Appeal in NCP said it was. again, we can see that the price that, or the sum that's consideration is not a price that was stipulated. In fact, you could have got exactly the same service by paying less, but that didn't mean that the excess was not consideration. So actually we can see two principles from these cases that interlink. The first is that the fact that the same price would have been payable whether the customer received one item or, let's say, 4 items, doesn't mean that the extra items are not being provided for consideration. So that's the same price, different amount of supply situation. That's M&S. In contrast to the same price, different quantity of supply, you've got the NCP case where you've got the same amount of supply but different price. And again, that doesn't stop any of that price being consideration for that supply. So I think my concluding thought for today, if I may, is simply to say that HMRC submission as to this concept of the price being stipulated is not an accurate reflection of where the law gets to. It's stated in those terms, but then when you look at the detail, as often in VAT, it's not quite what it looks like on the tin. So you can have a price arrived at in many different ways, including apportionment if you need to. And the suggestion that we should apply different rules as to whether we can apportion based on whether the supplies or the group of supplies has been made to one person or multiple persons is I would suggest, self-evidently wrong. That can't be a reason for finding that instead of just apportioning the consideration, we must say the whole thing falls outside of the scope of VAT. That seems a drastic solution to quite a simple situation. So where you have multiple supplies to one person for a single sum, you apportion. And when you have multiple suppliers to multiple persons, again for a lump sum, I see no reason of logic why you wouldn't just apportion again. Noting the time, I propose to finish there and consider overnight what I want to say tomorrow.
I'm very grateful. Thank you, Mr. Firth. And we will recommence at 10 a.m. in the morning. Thank you.